Welcome, everyone, to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This is a series run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences, along with support from the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, you can enter those in the Q&A box. You can enter those anytime you feel comfortable, but do know that we hold questions until the end, and oftentimes it's not possible for us to get through all of them. In terms of continuing education credits, if you are pursuing continuing medical education credits, there is a sign-in sheet posted in the chat box now that you can use to receive those credits. For those of you that are pursuing APA continuing education credits, there will be a link to a survey that you complete. That will also be in the chat box, but near the end of the presentation, near the top of the hour. So you'll keep your eye on that chat box as we're drawing to a close. Make sure that you save, bookmark, open up that link before the webinar closes. And once you complete the survey, make sure that you save your own PDF version of the certificate that you get from completing it. We don't have those certificates after the fact. If you missed our most recent talk in the series, Dr. Benjamin Silber's discussion of artificial intelligence use in forensic psychology is now available on our YouTube channel. The recording for this week's talk should also be available on our YouTube channel sometime later this week, and a version of the PowerPoint slides for those that have registered for the series will be available later this week as well. As a heads up, next week we have Dr. Michael Chavez, who will be discussing a forensic review of records and its impact on clinical judgment. But circling back to this week, I'm excited to introduce you to this week's speaker who will be discussing criminal legal outcomes for people with autism spectrum disorder. Today we have joining us today Dr. Colleen Berryessa. Dr. Colleen Berryessa is an associate professor at the Rutgers University School of Criminal Justice. Her research, employing both qualitative and quantitative methods, examines how psychological processes, perceptions, attitudes, and social contexts influence the criminal justice system, particularly in relation to court sentencing and forms of punishment broadly defined. She's conducted a large body of work on how autism spectrum disorder is perceived and used in decision-making in court settings. Dr. Berryessa received her Ph.D. in Criminology from the University of Pennsylvania. Before UPenn, she graduated from Harvard University with a BA in Government and Mind, Brain, and Behavior, and served as the CIRGE Research Fellow at the Stanford Center for Biomedical Ethics. I came into contact with her in a panel in a work group of people mindful of language we use to describe others in the legal system, and how principles of essentialism can affect legal outcomes. So I can say I am very excited for Dr. Berryessa joining us and sharing her expertise with us today. So Dr. Berryessa, Colleen, on behalf of the University of New Mexico, thank you so much for joining our series with us today, and we're excited to have you share your expertise. I will go ahead and toss it over to you.
Perfect. Thank you so much for having me, and thank you so much all for attending today. I'm very excited to talk to you about autism in the legal system. I'm going to share my slides, which I believe you all already have as a PDF, which hopefully should be helpful. And I am going to just turn off the closed captions as well, because those can be a little distracting. In that wonderful introduction, you were told that we're going to talk about autism spectrum disorder today and its impact on criminal legal outcomes. I have conducted a really large body of work in this area, including some papers that actually have just come out in the last couple of months, which has been great. It's an area we need a lot more research and work in. So I'm excited to talk to everybody today about this, and also interested in hearing your thoughts and questions as well. So this is my bio, and as Anthony did a wonderful job introducing me, I'm happy to also answer questions about that as well. This is all your information about the CE credits. So this is, again, all a part of your information. I don't have any financial arrangement related to the content of this activity, and the views expressed in this presentation and those of the speaker do not necessarily represent the views, policies, and positions of the University of New Mexico. So the learning objectives for this presentation, we are going to talk about the forensic relevance of autism spectrum disorder to both court settings as well as correctional settings. We'll talk about how different symptoms of autism may intersect with offending and courtroom behavior, as well as how misperceptions of symptoms of autism could lead to negative treatment of defendants in court and corrections settings. And then we also will talk about how and whether a defendant's autism can be considered or adjusted for during different legal proceedings and processes. So let's start with a definition of autism, which many of you are probably quite familiar with, but it is important to talk about not only the disorder, but also about kind of the area of autism that we're going to be really focusing on today. So autism spectrum disorder is marked by hypersensitivity, social deficits, and pattern behavior. It's diagnosed on a spectrum. And today, when I describe autism, I'm going to use ASD, but I really want us to focus on high-functioning autism. So high-functioning autism is diagnosed higher on the spectrum of autism spectrum disorder, and it's largely marked by social and communication impairments, a variety of the symptoms that are listed here on the screen. But the most kind of important defining feature between high-functioning autism and lower-functioning autism is the fact that people with high-functioning autism do not have any intelligence impairments. So they have normal intelligence and IQ above 70. And really, the marked symptoms that we see are associated with social communication. It could be social naivete, nonverbal communication problems, issues with perspective taking or empathy, sometimes showing inappropriate emotional social interactions or reciprocating emotions in inappropriate ways, flat and rigid affect and body language, and then also difficulty with motor control and physical clumsiness. And a lot of these are going to come into play when we talk about examples of cases today and their intersection with the criminal justice system. So there has been quite a large body of literature on autism and criminality over the last 40 years or so. Some of it has connected autism with criminality and different types of patterns of offending behavior, and especially this intersection between diagnostic characteristics and different types of offending. So you might see, people with autism have a higher prevalence of things related to cyber crimes or other types and different types of interpersonal offenses, which we'll talk about throughout this presentation and some of the examples that I was mentioning. There has been some high-profile media coverage of autism and its relationship to violence. Some of these have been really unfortunate instances in which autism has been portrayed or kind of scapegoated as it relates to autism. The Sandy Hook shooting, at this point, 13 years ago, is probably maybe the most kind of more common type of event in which autism has been discussed. In more recent situations, Brian Koberger, in the case of the Idaho 4, there was also discussion about his diagnosis with autism. And so there has been some relationship drawn in the media between autism and criminality. And this has caused, concern that this might lead to societal misperceptions about autism and its relationship to criminality. And that could lead to potential stigmatization in the criminal justice system. So there have been a lot of concerns from both mental health scholars, legal scholars, and other individuals who do work on autism that people might misunderstand the kind of coverage in this context and draw relationships or links between autism and violence, which does not exist. The research that has shown that has largely been debunked. There was some research that was done in the 80s and even earlier on where some of the methodologies were not necessarily robust, and a lot of work that has drawn that conclusion has been disproven up to this point. But what has been shown in a lot of not only case law, but also just generally discussions and examples of cases that have gone through the criminal justice system is that this, autism is something that is seen in the criminal justice system, and that decision makers who are tasked with making decisions on behalf of defendants with autism often are unaware of how significant autism might be to both offending behavior as well as to courtroom behavior. And so they don't necessarily know how autism might contextualize defendants' behavior and how they should potentially take that into account in the legal process when a person makes contact with the criminal justice system. So some of the symptoms that are potentially related to offending, as well as courtroom behavior, and again, we're going to talk about these today. There are potential symptomatic overlap and offending with impulsivity, motor control problems, lack of understanding of social cues, links to different idiosyncrasies and different fixations, potentially on like one specific interest, and then also acts out of sexual frustration. But it is, again, really important to point out that the prevalence of people within the criminal justice system who have autism is unknown at this point. There isn't necessarily very good data in knowing how many people with autism make contact, but we do know that the huge majority of individuals with autism are unlikely to offend. They are not in a position to make contact as a defendant regularly. These symptoms do not predispose someone to offend, but we are seeing an overlap in a notable number of cases in which autism is going to be relevant. And especially is important, again, because it can affect the outcomes of individuals with autism when there might be misperceptions about their symptoms and the disorder more generally, but then also a lack of knowledge and potentially a lack of training of people in the criminal justice system about autism and how that can potentially affect outcomes in both court settings and correctional settings. And so those are the two that we're going to be talking about today. So let's start with courts. So most of the time when individuals with autism offend, there is some overlap between the presentation of the symptoms of their disorder and the offending behavior. Then in the criminal justice system, sometimes these same behaviors can be demonstrated in court, and they may be misinterpreted and viewed in a negative light because of a lack of knowledge about how autism may present in both social and effective communication. The characteristics of offending in court behavior might be viewed as being evidence of guilt, of indifference about the case at hand, or a lack of remorse. Those are probably the most common. And again, I'll give you examples of some cases in a moment. And I wrote a law review article a few years ago when they did a conference on autism and its relationship to legal outcomes. I wrote a piece about different social and communication impairments and how they could be misunderstood in court contexts, and particularly how judges might be able to use information about autism to better outcomes for individuals with autism. And so the two that I talk about in that article and the ones that I'll talk about here are distinctive offending characteristics and then also impairments in the courtroom. So there are characteristics of autism, and the examples that are often talked about are social naivete. It could also be related to lack of perspective taking or difficulty with empathy. Those often can potentially overlap with offending behavior for individuals with autism. It's been characterized or described as 0 degrees of empathy by a famous autism scholar, where people with autism sometimes do have these difficulties with showing empathy and concern for others. They also often will have difficulty in identifying the emotional states of others, such as when another person might be afraid or in distress or anxious, and they may not necessarily know how to respond appropriately because they cannot necessarily read those emotional states. And that could potentially contribute to offending. So a famous case there was a man named Nick. He had high functioning autism, and he was convicted of the possession of child pornography after coming across it while using the internet to explore his sexual identity. And when he was describing his offense and really thinking about what had happened and kind of the events that had transpired, he showed a severe lack of awareness of the implications of him downloading and having those types of materials. So he said, at the time, I didn't understand that downloading free images on my computer in the privacy of my residence could lead to the severe consequences I later experienced. I also didn't understand at the time that the children in the images had been victimized in the process of creating those images. I honestly had no idea that I was causing harm to anyone. It is very embarrassing to me to admit that I needed to have this information spelled out for me, as I wasn't able to make that connection on my own. After my arrest, Dr. Green, who was his psychiatrist, spent considerable time explaining the issue of victim awareness to me. I was horrified to learn that these minors had been mistreated and that I had not been able to see that. So that's, again, a good example of not understanding the emotional states of others and how that could potentially lead an individual with autism to not understand the repercussions of one's actions. Another example that might overlap with offending behavior is social naivete. So individuals with autism may have difficulties making friends, and they also might be taken advantage of and mistake when someone might have malicious intentions to want to, get something from them and exploit them. They may believe that that's friendship when in fact it's not. So an example is a man was arrested after stolen goods were seen in his front window. The man had autism. It was later found that a neighborhood gang frequently used him to store stolen items in exchange for allowing him to hang out with them. So in that case, he was holding stolen items, and again, he held them in plain view, not understanding the repercussions, because he wanted to have friends, and those friends knew that he would hold these stolen goods for them, and therefore they exploited him because he wanted to have friendship. Another example is insensitivity to social cues. So that may mean that those with autism may be unable to understand unspoken social rules. So some examples that have been seen in some of the case law is that you might have individuals who stand too close in kind of personal space. Another example would be maybe being in a situation where you're looking into someone's private residence when you shouldn't be, kind of as like a looky-loo or a peeping Tom, not realizing that that's inappropriate to look into someone else's home. And so there are several cases that I've read about and that have been described where this insensitivity to social cues might lead an individual to overstep boundaries and make people feel uncomfortable, which potentially could lead to assault or other types of offenses. Social niceties also are a potential difficulty. There have been many cases in which social niceties, again, common social niceties that a person might have, like smiling at another person when they make eye contact or things like that, as a sign of romantic interest. And so those social niceties might be misunderstood as those romantic interest signals, which could lead to a person with autism potentially pursuing this person for a romantic relationship, even though that those signals were not there and it was just a social nicety. So an example is there was a man with autism who was charged with assault after rubbing a stranger's body after she briefly smiled at him just in a very quick social interaction. She didn't know him, and he was using that kind of touching of her as his attempt to get to know her because he believed when she smiled at him, she was showing romantic interest. So those are some examples, again, about how the overlaps of autism symptoms might be seen in offending behavior, which again is important to make sure that decision makers in the criminal justice system are fully understanding how symptomatic presentation can overlap with offending. And maybe in some cases, I mean, the individuals with autism don't really actually understand why they are in the courtroom, that an offense has actually taken place. But we often will see the same types of symptoms that we've been talking about also create impairments in the courtroom. So a good example is because individuals with autism might have difficulty in appreciating other people's perspectives or subjective experiences or emotional states, as we've been talking about, defendants may not exhibit empathy or show appropriate facial expressions in court. They may be in a situation where they do things that people may view as being very callous or as potentially aggressive. So an example is that there was a person with ASD who was on trial, and he was casually reading a book while his alleged victim spoke on the stand, and he smiled at her when she made eye contact, and it was misunderstood that he was being malicious, that he was being aggressive, and it was almost like a threat that he was smiling at her in that regard, when in fact he actually had just been taught by his mom and by his caregivers growing up that when someone gives you eye contact, you should smile at them because that's a social nicety. But in this context, he did not realize that this social situation would not lend itself to him smiling at her in that regard, and that it would be construed in a different way. So there are concerns that that behavior might be misunderstood in the way that I described, and it may make defendants with autism appear more cold and calculating than they really are, in the sense that they may be viewed as lacking remorse or lack of understanding the kind of effects that their behavior has had on victims. When in fact they are often just unable to read the social cues or information that's provided to them. Defendants with autism also may say things that appear to be inappropriate and callous, which could be misinterpreted as being arrogant, dishonest, or guilty. So there was an example of a defendant who laughed during the trial when he was on the stand and he was being questioned. He laughed in the middle of the questioning, and that was viewed as being callous and guilty, when in fact he felt very socially inappropriate, and in the sense that he was very uncomfortable and felt very anxious, and therefore was just laughing anxiously, but it was misconstrued as him being remorseless. Defendants also may show no interest in proceedings, in the sense that they may show absolutely no interest when witnesses are being questioned, when the judge is explaining instructions to the jury, or other things in which the legal process is kind of moving forward. Defendants may show actively that they are not interested. They also may avoid eye contact with individuals in the courtroom during the entire trial. This again might be misunderstood as someone feeling shame or someone not owning up to their behavior, when in fact it might be, again, because of the potential anxieties associated with social situations. Sometimes people with autism do not make direct eye contact in those types of social situations, and therefore avoiding eye contact alleviates that anxiety and that stimulation. And so that is something that might, again, be misunderstood as a shame or as guilt. And it might be something that is viewed by the judge, by a jury, or by other individuals as being negative, and either as being potentially aggressive or callous. Individuals with autism also might exhibit unusual speaking patterns, such as formal or odd phrasing or responses to non-literal language. So things like allegory or sarcasm are often misunderstood and may be taken in an inappropriate way by people with autism, and they may not be able to answer things. And because of that, they might be viewed as being evasive and not answering or providing a direct answer to a question, when in fact they may just not understand the question that's being asked of them based on the type of language. They also may take a long time to answer their questions, in the sense that they may have to think about what they want to say for a significant period of time before. And that could be viewed as being evasive, or not listening or taking the legal process seriously. They may shout out unrelated words or phrases because of a misunderstanding that they're not allowed to speak out of turn. And then they also may nitpick questions that are asked of them, so focus on language, on specific things or unrelated things in the asking of questions, which again could be misunderstood as being evasive, or as not taking the process seriously. They also may fail to pick up on cues that signal the end of a line of questioning or attempt to shift the conversation to a topic of their interest. So they might be being questioned or cross-examined, and it might be a natural end to the question, but they may continue to speak when the question has been answered. And they also might, again, focus on specific things that are very unrelated to the question being asked, because they want to talk about something, not realizing that they are not supposed to do that, which means that, again, it might be viewed as them being evasive, of trying to change the subject, and just not taking the process seriously. A good example is there was a defendant with autism who instigated arguments with the prosecutor over comparatively trivial details while failing unless redirected to confront the underlying and criminal question. And in that case, the person, again, was really focused on language that was being used, and would not answer the question because of the type of language that was being used, where it was, again, misunderstood by people in the court that individual was again, really explicitly focused on that language and not trying to be evasive. It was being misunderstood as him not wanting to answer the question because he was hiding something. So the implications of these, so members of the court need to be able to recognize and have appropriate awareness of the symptoms of autism, both in offending behavior, so recognizing how they're a person with an autism diagnosis, how to make sense of the offending behavior that's at hand and the forensic relevance of autism to the offending behavior. And then within the courts, also trying to understand and recognize those symptoms to try to better identify and handle those defendants, to make sure that the legal legal process is both, adjusted if possible, and we'll talk about some of those adjustments in a bit, but then also just so there's a wider recognition that things like evasiveness or a lack of remorse might actually just be a symptomatic presentation of autism in that type of social situation. Legal representation also need to understand how their clients with autism may be viewed or misunderstood before and during court. I had a piece of an article that just came out a few months ago that was led by a graduate student of mine, where we interviewed defense attorneys in the United States who have represented clients with autism, and they talked about the things that they encounter during their representation of those individuals, how they think about advocacy and other things for those types of individuals, and how there's a lot of learning on the job. There's a lack of often formal information or education on these in the legal setting, and that can be obviously very difficult when you're trying to deal with a person's case, when you're trying to do the best job that you possibly can, but you may not necessarily know how to approach being a representative for that individual, as well as when one should potentially engage expert testimony or consultation, and we'll talk about that as well. By making sure that everyone is kind of on the same page and there's some recognition of that person's autism within both an offending setting and a court setting, it does allow for us to think about accommodations and a more holistic understanding of autism and how it's forensically relevant to the legal process as well as to the outcomes. And experts are going to be really important to help the court understand these things, especially when the behavior is going to be really important to the potential outcomes of individuals, as well as kind of understanding their behavior before and during the legal process. So I'm now going to shift to autism and incarceration. So many defendants are either not diagnosed or their diagnoses are not known to the court. Again, we don't know prevalence, but there are a large number of individuals that their autism diagnosis either occurs after they go through the legal process, or that autism diagnosis is known but is not shared with the court because it is not known that it is relevant to be shared with the court. And that, again, can be extremely problematic. It's difficult for people who are diagnosed and how it's integrated. It's even more, compounded and difficult for individuals when their diagnosis is unknown, or if that information is not available to the court. And again, it's very important because it's necessary to be able to think about the legal process and think about sentencing particularly, and how different types of outcomes, and in this case, we're talking about incarceration, can be really, really detrimental to individuals who are on the spectrum. So sometimes unusual or maladaptive behaviors demonstrated during offending and in court by a defendant also can be problematic in incarceration. And again, because sometimes they can be misunderstood during the legal process, it may mean that decisions on their behalf by a judge or a jury or other types of procedural decisions that are made, sometimes it means that they, again, are viewed as being callous, evasive, which could lead to very negative outcomes that could skew those outcomes to being more punitive. And so I'm now going to talk about 3 different areas in which we should think about autism related to incarceration decisions and sentencing. So first, I'm going to talk about difficulties for individuals with autism during incarceration. Then I'm going to talk about how autism and should autism affect the objectives of punishment when judges think about how they punish individuals within their discretion in the criminal justice system. And then also I'm going to talk about some recommendations for incarceration decisions, both for legal representation as well as for judges when thinking about making accommodations for defendants with autism moving forward. So similar to what we've been describing about how difficulties with social cues and a misunderstanding of social cues, how that can cause issues in the courtroom, it can also cause difficulties for individuals when they're incarcerated as well. So misinterpreting unwritten social cues and rules may cause conflict between defendants with autism as well as with other prisoners. That this could be, interactions with people who are incarcerated with them in their cells or within their facilities, but it also can extend to corrections officers and people who work in the system as well. Sometimes difficulties with perspective taking can also make them less likely to understand common social rules, in the sense that we talked about a case of an individual looking into someone's house, not realizing that it's inappropriate to like look into someone's house and look at their belongings or what they're doing. That can be also seen in incarceration settings where there might be a lack of understanding that you shouldn't look into other people's cells or touch their possessions or go through their possessions, and kind of that element of privacy. Issues with socio-emotional reciprocity can also impair individuals with autism in interpreting and responding to social situations in prisons. This can lead to aggression, particularly engagement in fighting or altercations. So you might be in a situation where someone is being aggressive or showing aggressive behavior. And a person with autism may not be able to identify emotionally that that person is distressed, or that that person is potentially in a situation where they might lash out. And therefore, they may engage with them in an appropriate time or way, which could potentially lead them to be assaulted or get into an altercation with another person in an incarceration setting. For social naivete, we talked about how people in the thinking about offending behavior, how people can be exploited by others and hold things like stolen goods for one another. This can also be seen in incarceration settings as well. People with autism might have a higher likelihood of being victimized, exploited, or manipulated by other prisoners. This isn't exclusively related to prison gangs, but that is something where some of this has been seen in prior literature, where they may see there might be groups that show interest in them and will show them either protection or provide them goods or things like that. And it might be because they are, again, looking for followers or for other things. They may have malicious intentions, and they may be exploiting them, but it may be misunderstood by the person with autism is that group of individuals is showing them, friendship. So that can be really difficult and can lead to potential exploitation in incarceration settings. Another thing that we haven't talked about a lot yet, but is something that is both relevant to here, but also in courtroom behavior, is that often prison and jail settings are extremely overstimulating environments. They, have extreme focus on routine. They have bright lights. Things are very noisy, and it can create a high level of sensory overload. That is something, again, that can also be seen in a courtroom setting. So obviously in a courtroom setting, you can have very bright lights. You can have very regimented environments and a lot of rules that have to be followed. A lot of those those kind of stimulating environments and overstimulation related to kind of sensory products, whether that be noise or things that you visually can see like light, those can potentially lead to individuals feeling very, very uncomfortable and then act out because of that anxiety, which can lead to reactive aggression. And in fact, one of the cases in which I've used a lot in some of my work, where I've presented someone a real case about an individual with autism, was really about this reactive aggression. Sometimes, there are cases in which an individual, when they're offending as well, might be put in a situation where they feel like their back is up against a wall, or they're in a situation where they can't move, or they feel very constrained, and they may react aggressively, not because they're looking to harm individuals, but because they are stimulated and they're trying to get into a place where they feel more comfortable. So they may move their arms or legs or use things in a way that they don't realize, weaponize them, and lead to someone being harmed. So in an incarceration setting, you can again see individuals act out. It means that they can both act out and get infractions because they're acting out. Because when you're incarcerated, you potentially are in a situation where you might get points against you, which could make it less likely for you to be able to participate in programs or be paroled or whatever it might be. So you may see infractions incur for individuals with autism for a lot of these reasons, but you again also might see them reactively aggress against other individuals as well because of that anxiety and the overstimulation. A lot of the communication problems that we were talking about before, that also may hinder interactions, not only with individuals who are incarcerated with them, but also with staff and other people as well. We talked about unusual speaking patterns or nitpicking other person's language and behavior. They may do that with members of authority in a correctional setting. So they may interact with corrections officers or a warden or whatever it might be, and they may hyperfixate on language or talk back in a way that is viewed as having an attitude or having a problem. And that could lead potentially to them, again, gaining these infractions and elongating their time in an incarceration facility. So, I wanted to talk a little bit now about thinking about why we punish in the criminal justice system and how that kind of intersects with incarceration and sentencing outcomes for individuals with autism. So in 2016, a long time ago now, I did a study with judges, state court judges, where I was interested in how they think about autism and its impact on their views about sentencing and the different types of outcomes that potentially could be available for an individual with autism. And so judges had a lot of kind of interesting perspectives, and most of which were, again, were very sympathetic and very interested in using outcomes for positive rather than negative. So I had one judge who said, it's a matter of assessing the seriousness of the conduct, the effect on any victim, and just considering the problem in that context, and also considering perhaps the different effects that certain penalties like incarceration might have on someone with a disorder. So you can see the judge here is talking about trying to figure out these like legal factors. So trying to figure out how serious the conduct is, what the effects have been on victims, considering the whole kind of case in totality, but then also how punishing or the outcomes of the criminal justice outcomes for that, how that might potentially affect a person with autism, how incarceration and other types of more traditional criminal justice settings might affect someone with autism. And so that was something that I found to be quite common in a lot of the discussions I've had with judges. And again, it's not just the study. I've interacted with judges and other decision makers in a variety of contexts related to autism. But there really is this consideration about how do we treat the behavior and address the behavior in an outcome in a just way, but then also how do we factor that into thinking about how these outcomes could potentially affect people with autism. Another judge said, can I find some form of treatment that might be more effective than, say, incarceration or a prison? I don't generally find that jails and prison cells are effective in dealing with people who have, emotional, psychological type problems. When they're placed in a jail or a prison cell, they're being basically warehoused because we don't have any better way of dealing with it. So in this context, the idea is trying to think about the objective of the incarceration to actually have an effect, the utility of the outcome, and trying to figure out, in this context, the judge saying, I don't think that prisons and jails are good in most instances with individuals who have autism. But so when they're placed in those, they're in a situation that's not good for them, and we need to try to figure out a better way because that's not working. So really thinking about the potential outcomes and again, how they intersect with the well-being of individuals, but also not really sure how to deal with it because they're not sure if there's a good enough alternative to be able to deal with individuals with autism. And then another judge said the judge is going to be concerned that he may do it again. On the other hand, there will be some sympathy, and the reaction would be, can we help him? What can we give him rather than jail that would help us avoiding it happening again? So in this context, really trying to figure out, you feel badly about the whole situation, but it's not so much just about sympathy. It's about what can we actually do to make this not happen again? Is prison or jail or an incarceration setting going to have the objective we want it to, or is it not going to have any sort of long-term effect and really kind of help this individual avoid offending in the future? So I wanted to give these quotation examples to show you how judges kind of try to weigh a bunch of these things and think about the objectives of incarceration and objectives of punishment more generally. Because yes, we'll see in the next few slides that a lot of the kind of considerations related to incarceration and outcomes may not necessarily be helpful for individuals with autism in the sense that they may not actually gain utility. Incarceration may not gain utility to prevent future offending. When we think about sentencing in the United States, we think about we want our sentences to have a goal. We want them to deter individuals. We want them to think about what they did and rehabilitate and all these things. But it's possible that in instances related to autism, that incarceration is not going to necessarily help us achieve a lot of those goals. So for some kind of examples and ways in which these objectives of incarcerations can be complicating. So although individuals with autism may cognitively understand that their behavior is illegal, they often do not appreciate the socio-emotional implications of their behaviors. So an example of a pretty famous case is that there was a woman with autism who wrote letters in search of friendship. She wrote a bunch of different letters to a variety of people who she didn't know very well, but were kind of within her, I believe she was at school, so it was a bunch of people, fellow classmates and things like that. And she was arrested when she kept writing the letters and they weren't responding to her letters and they started to become kind of threatening and aggressive. And she even continued to send these letters after she was arrested, despite clear warnings from police that she needed to stop because individuals did not want these letters. They did not want to have this communication and they were feeling uncomfortable. And it really demonstrated her inability to understand the impact of her actions on the recipients of the letter. Really didn't understand those socio-emotional implications on the individual she was communicating with. And this kind of, again, leads us to think about how we kind of address her behavior in that instance. She does not understand the implications of what she did. How do we go about punishing or giving her a sentence that might be able to actually address the situation by putting her in a situation where she was incarcerated, for example? Is that actually going to help us avoid it happening in the future? And probably the most famous and most interesting example that I usually use when we think about how autism should affect the objective of a defendant's punishment or how it should be factored in is there was a case of a defendant with autism who was found guilty of possession of child pornography. It was similar to kind of what the kind of initial example I gave you guys, where he had accessed this information during a time period of trying to find sexual identity, and he just had this on his computer, and he was sentenced to 8 years in prison. He had a defense expert testify, a psychiatrist, about his autism, and the expert said that due to his autism, he would likely be victimized in incarceration settings by other inmates, that staff would likely misunderstand his behavior, and that the expert also said that he would likely not gain any benefit from being incarcerated because he still didn't fully understand what had happened and why he was being tried, and kind of the implications of the behaviors that had led to his incarceration. So he was incarcerated for a period of time and then he was released. And later, when he was asked about his time in prison, he explained that what did you learn? He was asked about, again, what he achieved from prison. And he explained that he practiced math questions and he learned that math skills could potentially earn him a significant amount of money upon release. And that was his biggest takeaway and the most important thing he learned about in prison. And so it really showed he only understood how prison benefited him and did not express any understanding about his actions, about why he was in prison, that his actions were wrong, that incarceration had led him to understand the errors of his ways, that it would prevent him from moving forward or to change his life. And so this is suggestive of an interesting perspective to just kind of think about, and maybe an interesting thought experiment to discuss philosophy of punishment, to try to figure out when we think about why we punish and we think about the objectives of incarceration for individuals like this person, how should we go about configuring those decisions? How should judges and other sentencers in situations think about how these sentencing outcomes, what they will achieve, and how they will potentially benefit a person or society at large when it may not necessarily have the expected outcome or an outcome for an individual that doesn't have autism. So I want to, I'm going to talk a little bit at the very end of the presentation about experts in autism cases, but I do want to make some recommendations based on kind of some of the things that I've discussed here. So punishment for individuals with autism it's now been discussed, again, not just by me, but by legal scholars and mental health scholars, that autism and it's the need for punishment really should just be long enough for the message to be effective. And incarceration may not always provide an appropriate message or objective in relation to punishment to actually facilitate change or kind of benefit society's interest. And so alternative non-incarceration based sentences with more holistic and less retributive objectives may be best in certain cases, especially in cases like some of the examples I mentioned here, where individuals are still very unaware, even into their incarceration, even after the legal process, really about why they have been incarcerated and really about the kind of socio-emotional implications that we're talking about. As incarceration may increase an individual with autism's risk of being exploited, harmed, or socially isolated, this vulnerability should be considered when weighing whether prison is appropriate. Non-incarceration based sentences may be more effective for rehabilitation, whereas incarceration may be more taxing and toxic. So again, I'm not talking about, blanket statements in this context about every single individual with autism, but it is really important to think about defendants with autism, how in many instances incarceration can be very, very toxic for individuals. And it may mean, that they're in a situation where they come out far, far worse than when they went in, both physically, emotionally, psychologically. And therefore, when we think about sentences, we may want to try to maximize our interest in non-incarceration based sentences or other types of programming that might be more beneficial to individuals with autism. So yes, defendants may benefit from diversion or probation programs. They are especially potentially going to be appropriate when they provide clear expectations and guidelines. As you kind of mentioned, or at least tangentially related throughout, often people with autism, need like rules, they like routine. And so integrating those rules and routines into programs and also integrating the support and participation of families and other contacts, providing that support can be really helpful and can really help individuals kind of keep a part of these programs and really excel in these types of programs. And there has been some evidence to suggest that that can be helpful. And then that those things might be a lot more effective in preventing recidivism. And then corrections personnel should also be notified about the defendant's autism before incarceration, in the sense that it shouldn't be a surprise or something that is adapted to after an individual has already been placed in an incarceration setting. And that's because we want to identify individuals and communicate that early on, just if there is potential modifications for individuals with autism in those settings, they should be made as early as possible. So a good example is that judges could recommend that a defendant be segregated from general population or monitored by medical personnel, depending on the situation. And it will just allow for a more appropriate prison or jail conditions if a defendant is going to be incarcerated. Because again, there are going to be instances in which, for public safety or for a variety of other reasons, incarceration is going to occur. And so we just want to make sure that in that setting and in the ability of what the corrections facility and the courts generally can do, that whatever modifications are possible are undertaken. So my last couple of slides, I just want to touch on expertise in autism cases. So, generally the roles of experts and consultants in different cases are really to act as educators of the court, meaning that they're there to provide expertise and knowledge in an area that people in the court is not knowledgeable on. And this can be especially difficult for experts who assist in cases involving mental health evidence, including autism. In recent years, there have been a lot more cases in which autism evidence in cases involving autism has been kind of increasing and presented in courts, and it just shows that, again, this is incredibly relevant information, but also something that is unlikely to subside moving forward, and we're likely to just see more of a presence or at least discussion of autism in criminal cases moving forward. And in these instances, experts are really often really important and imperative to make sure that legal decision makers understand autism and that they have the appropriate level of knowledge in order to make decisions and especially ensure fair decisions and outcomes for individuals with autism. And again, a lot of the things that we've talked about today, you can imagine how expertise in providing information to the court is going to be really beneficial in better understanding the offending behavior, the courtroom behavior, as well as the potential implications of sentencing to incarceration. Um, So the last thing I'll mention is that there is some research that I've done on expert witnesses and people who've given expert evidence in autism cases. I did a study of experts in 2017 where I was interested in how they think about and approach their roles in cases involving autism, and I found that they're influenced by a variety of different factors. They're influenced by internal factors. And so that's largely experiences in previous cases, because again, many of them had done hundreds of autism cases to that point, as well as external factors. So general views and knowledge and background and other types of kind of external stimuli. And all of those kind of coalesce to help them view themselves and think about their roles in autism cases in three different ways. The first is that experts described that they act as reconstructionists, meaning that they retroactively assess how autism has potentially contributed to criminal behavior on trial and the offending behavior to be able to try to reconstruct what's happened and illuminate the court to what has happened and how autism might be relevant. They also are there to act as communicators, so educating court on legal aspects of autism and distinctive ways in which autism and its symptoms could affect behavior, not only related to offending, but in the court itself, and as well as daily life and life moving forward. And then experts also must act as myth dispellers, so attempting to dispel inaccurate societal misconceptions about autism and its symptoms. And this largely goes back to what I was describing before, where we might have, high-profile cases that connect autism with violence or other behaviors that could potentially portray individuals with autism in a negative light. And experts want to make sure that if there are societal misperceptions about autism, that that's dispelled and not taken into account or is not influential to decisions that are being made in a court context. So that is the end of my presentation. I have three references that I gave you, three papers that I have written in the last 10 years about autism, although I've written a lot more. And so I'm happy to share those with people that are interested. And as I mentioned, I've had a couple of papers that have come out in the last couple of months too on autism as well. So hopefully that can be of interest to people. And then this is the QR code that you guys have. I will put that up for all of you. Would you like me to keep this up, Anthony?
Yes, you can keep that up.
Okay, perfect. So I'll keep this up.
Wonderful. Thank you so much, Dr. Berryessa, for that
Of course.
overview of a lot of the work that you've done and a lot of different ways that issues related to autism spectrum disorder can impact legal outcomes here. We do, of course, have a number of questions here. We will not be able to get through all of them, but we will ask a few of those. In the meantime, of course, in the chat box is the direct links for the CEU credits. Make sure that you save bookmark, open that link now before the webinar closes for those of you that are pursuing APA continuing education credits. But Dr. Berryessa can answer a few questions now. In the meantime, I know that through this talk, you've used a couple of different terms. I heard through the latter part, association people with autism spectrum disorder. Early on, we had several people that wanted to know about the use of the term high functioning autism, and particularly that people in the autism community have often moved away from high
Yeah.
functioning as a label. And
Yeah.
could you comment on that?
Yeah, no, so there's been a lot of changes to terminology in recent years. Asperger's was the diagnosis for what we would consider in this case high functioning autism in until 2012 or 13 when that version of the DSM came out. And now, yes, we are moving away from the high functioning, low functioning descriptor. I use that largely here because the literature has not moved away from that as much. And so I wanted to be very clear on what we were going to be focusing on today. And so the terminology has, as people have said, has lost favor in the sense that it is not something that necessarily is being used. Although it is interesting, there has been some within the autism community that are attempting to kind of regain control over some of these labels. So I know the term Asperger's is something, again, that isn't diagnostically used, but is now in an advocacy way, still very much sometimes used within autism communities themselves. We actually did a article not that long ago where we were explicitly told to use the word autistic individuals as compared to individuals with autism because of that reclaiming of the label. So there's a variety of different ways in which I think people are thinking about these labels more generally. But yes, I agree with you. It's not meant to be done in a derogatory way. It's more about me trying to make sure that people were of understanding because again, that term is still being used, and I want to make sure that people understood that when I'm talking about autism today, it was individuals with with an IQ of above 70 that were really again related to those marked social and communication issues to make sure that we were understanding that that's the individual set of individuals we were talking about, those that have been described as high functioning autism in the past. So I want to make sure that it was not meant to be a derogatory term.
No, well, thank you for that clarification and that context there. We also have several people that have asked questions related to competency examinations. So we probably have a number of forensic evaluators here who are doing evaluations, knowing whether to evaluate whether somebody understands what's going on with their legal
Yeah.
case, but also can they rationally assist with an attorney, rationally assist with their defense. One representative comment that says, when considering how autism spectrum disorder can impact communication, behavior in court, understanding right or wrong, what are your suggestions for considering the potential impact of autism spectrum disorder on someone's competency to stand trial?
I was going to say, so that is a really good question. As we know, competency is a very difficult construct, and it can be very difficult. Again, it's not just specific to mental health. You know, juvenile competency is also very difficult because there's a variety of different almost like ephemeral, like not black and white, like factors that need to be weighed in a lot of these things. So yes, I actually have a graduate student who is working on a project right now on autism and its relationship to competency evaluations. And yeah, a lot of the symptomatic features that I described, one can imagine that it can be very difficult to, it can potentially affect a person's ability to mount one's own defense, work with one's attorney, give them the ability to fully understand the legal proceedings. All of those things that are things that, especially those who are representatives, as well as court evaluators and things like that, need to make sure that they are using questions and having discussions with individuals with autism in such ways where they're asking questions to be able to measure those. Unfortunately, at this point, it's largely qualitatively in the sense you're trying to get this information by having these discussions. But I assume that there is quite a bit of overlap and a lot of relevance to many of the features that I mentioned today in trying to figure out whether or not someone is competent.
Wonderful. And I guess somewhat relatedly, a couple of people have asked about criminal responsibility, so insanity kind of
Yeah.
evaluations. Are you aware of any states that allow for an insanity defense for autistic individuals? And in this person's state, they said neurodevelopmental disorders are explicitly excluded.
Yeah, I don't know off the top of my head. It's not my specialty. I do know, as that person said, I do know that there are many states that specifically prohibit neurodevelopmental disorders from being used for insanity defenses. But it is not something that I characteristically have heard, particularly for the type of autism that I'm talking about today, where intelligence and IQ is in disability is not a factor as much.
Sure. Thank you for that. We have some similar or some another people have had some multiple questions about differentials between autism spectrum disorder versus anti-personality disorder. And of course, these things are not necessarily mutually exclusive. But somebody
Yeah.
asked, can you speak a bit about a differential there? What would be some things to look for in co-occurring autism spectrum disorder and antisocial personality disorder?
So that's a very good question. It's actually something that in the literature, so initially when autism was identified, especially Asperger syndrome, that, as I mentioned, was termed as a term that is now not being used, but was something that was used for a significant period of time. It was initially described very, very early on in the literature as being a basically version of antisocial personality disorder. In fact, it's not, but it was described as having similar presentation in the sense that you are seeing lack of empathy, you're seeing lack of socio-emotional understanding and perspective taking and things like that. So there are a variety of different symptomatic features that one can see that might potentially coexist, but it isn't a personality disorder. So you're not seeing, I think probably the most marked thing that would be different between the two is that instrumental aggression or that instrumental planning of antisocial behavior. With autism, when autism and offending occur, it is not often planned in such a way where there is looking for malicious intentions. It's often done in such a way where it's either reactive or the chain of events have occurred where there has been a misunderstanding or again, a lack of understanding of the behavior at hand. So there's not a lot of active planning of an assault or for physical aggression, where in antisocial personality disorder, not always, but many times you see instrumental aggression and steps that are moving towards that. But there are certain similarities, again, when we come to things like difficulties with emotional appreciation and things like that.
Wonderful. I do want to be mindful that we have passed the top of the hour. Somebody did ask if you could speak to any in-court accommodations that have been provided and useful for people with autism.
Great questions. So, lowering of the lights is probably the most common. Potentially removing people from the courtroom who do not need to be in the courtroom, to prevent overstimulation, loud noises. Sometimes it's putting people at the same level, so putting everyone at a table rather than having kind of the traditional criminal justice structure. Having the sometimes having things written out in such a way, or providing instructions or context to individuals, letting them know that they can wait as long as they need to answer a question, providing alternative language, making sure that when you have a set of questions, making sure that you have someone go through and make sure that non-literal language isn't being used. There's a variety of different ways in which the kind of spookiness and scariness of the courtroom can potentially be alleviated in some capacity, which usually is reducing stimulation and reducing kind of aspects of the court process that can be really confusing or kind of anxiety provoking to people with autism. But great question.
Dr. Berryessa, Colleen, thank you so much again for
My
joining
pleasure.
us here, sharing all the work that you've done, your contributions to this area, and then addressing all these additional questions. It is much appreciated.
Wonderful. Thank you so much.
And that wraps up this week's Law and Mental Health series. Next week, we have Dr. Michael Chavez, who will be discussing review of records and the processes we use for that and how it can impact our clinical judgment. We hope you see you then for another great discussion of issues in behavioral health and the law. Until next time, take care.